New USCIS policy update, August 2026. Why every EV2NIW applicant must pay attention. Today, I want to share a very important USCIS policy update that could significantly affect anyone applying for an immigration benefit, including EB2NIW, EB1, adjustment of status, and many other petitions. On August 5th, 2026, USCIS announced a policy update that reinforces one simple message. Your initial filing must be complete from day one. For many years, some applicants believed they could submit a basic petition and wait for USCIS to issue a RFE or request for evidence to provide the missing documents later. This new policy makes it clear that this is a risky strategy. USCIS officers now have the discretion to deny a case without first issuing an RFE or a notice of intent to deny if the required initial evidence is missing and the applicant has not established eligibility. In other words, an RFE is no longer something you should expect. It is something you should consider a possibility, not a guarantee. Another important change involves RFE response deadlines. Many people assume they automatically receive 12 weeks to respond to an RFE. That is no longer the expectation. The regulations allow USCIS to provide up to 12 weeks, but officers may set shorter response periods depending on the circumstances of the case. The policy also removes the previous practice of automatically providing additional mailing time for applicants outside the United States. Instead, response periods will follow the regulations more closely. So, what does this mean for EB2NIW applicants? It means your petition should be treated as a finished product, not as a draft. Before filing, make sure your petition includes everything: every required USCIS form, the correct filing fees, all mandatory supporting evidence, a strong petition letter, well-organized exhibits, high-quality recommendation letters, clear evidence supporting all eligibility requirements. If USCIS requests additional evidence, that's fine, but your goal should never be to rely on receiving an RFE. As someone who successfully prepared and filed my own EB2NIW petition without an attorney, one lesson I always emphasize is this: build the strongest possible case before you submit it. A complete, organized, and evidence-based petition not only gives USCIS everything needed to evaluate your eligibility, but it also reduces uncertainty and unnecessary delays. Finally, remember that this policy doesn't change the EB2NIW eligibility requirements or the legal standard. What has changed is how USCIS may exercise its discretion when applicants submit incomplete petitions or fail to provide required initial evidence. So, if you are planning to file an EB2NIW petition, don't think of the initial filing as the first step. Think of it as your best and possibly only opportunity to present your case. Thank you for watching. And if you are preparing your own EB2NIW petition, focus on building a complete, well-documented application from the very beginning. That preparation can make a meaningful difference in the outcome of your case.